Lordship.
Yes.
Beg to mention item number 7.
This is a long pending matter.
This long pending matters, Your Lordship, I supposed to bring some record that's regarding this, whether
Yes,
ban
we
is
are-
withdrawn or not. So, Your Lordship, in this case, this officer here, I was not getting to them because they are in officer, this tour duties, and none of the officer is here.
It cannot be an excuse.
It will come after 2 weeks, Your Honor.
Who's the?
I tell
Mr.
Mr. Jaw's last question I discussed with him.
No, have you sought his consent today?
Already I talked to him, Your Lordship.
On pre-made by the Lanet CGC, this is matter after 2 weeks.
And another is item number 12, Your Lordship. Yes, item number 12. I have taken consent, Your Lordship.
You are there?
Objection. No objection, Your Lordship.
On pre-made by the. You are for respondent?
Respondent number what?
1, 2, 3. Pre-made by respondent 1, 2, 3. Not objected to by petitioner. Matter is adjourned. Discussing after 2 weeks.
Any bench.
Hey, please, Your Lordship. I beg to mention item number 9, Your Lordship. It can kindly come up after 1 week, Your Lordship.
No objection, my lord.
Lordship, I'm appearing on behalf of respondent number 5.
Any objection? On pre-made by the petitioner, this is matter after 2 weeks.
Item number 5, my lord, Kamesh Kumar Roy. And this is in the hearing list.
Yes.
Lord, because on the last occasion, my lord, I had entered appearance. My lord, I had sought for time for filing rejoinder. My lord, this honorable court was pleased to grant me time, my lord. However, last chance was given. This is the only time, my lord, I had entered appearance. My lord, the affidavit is, rejoinder is ready, my lord, but there are some mistakes. So my humble prayer, my lord, before this honorable court, my lord, I'll try my best to file it today, my lord. If I'm unable, my lord, if my lord kindly gives me the indulgence to file it either, if I fail today, my lord, either by Monday or Tuesday, my lord.
Mr. D.P. Bhattacharya, letter counsel for the petitioner, has submitted that the rejoinder directed to be filed by today is ready. However, it is noticed that there are some mistakes which requires to be corrected, for which indulgence is sought for the same to be filed in course of the day or within the next few days.
My lord.
On pre-made, the same is allowed. This is not after 1 week.
Oblige.
Much.
Much obliged.
Your Lordship, I beg to mention item number 18. Your Lordship, let it go after 2 weeks.
You are for?
Appealant.
On pre-made by the appellant, this is matter after 3 weeks.
Pleasure.
Please, Your Lordship, I beg to mention item number 4. Your Lordship, let this matter come up for after 2 weeks.
Another 3 weeks.
2015 matter.
My lord, yes.
See, we are,
Your Lordship,
you are the petitioner.
Yes, Lordship.
You should have pressed your case, in spite of the fact that at some point of time there was some overtures by the respondent for, giving you compensation, adequate compensation, or otherwise.
Your Lordship, the arguing counsel is indisposed, Your Lordship.
I have been to inform also, my lord, already, that he will not be arguing this matter.
1 week.
My lord, make it 3 weeks, my lord.
Why 3 weeks?
My lord, I have some difficulty in the coming weeks, my lord. I may not be available, my lord. I'll be going out of session.
2015 matter. 2 weeks at the
As
moment.
to lordship convenience, my
2
lord.
weeks at the moment. We'll see.
My lord, yes.
As and when the matter
The
comes
matter
up,
comes.
then you can, if you're inconvenienced, then you can
My lord.
make your,
We'll convey to the court.
on prayer made by the parties, list this matter after 2 weeks.
Your Lordship, similar prayer for item number 10.
Your for
Respondent.
For the petitioner, Your Lordship.
on prayer made by the petitioner, list this matter after 2 weeks.
I leave Lordship.
May I please, Your Lordship? I beg to mention item number 17. Let
You
us
are for?
meet I'm for appealing, Lordship.
For the respondents, Your Lordship.
On prayer made by the appellant, list this matter after 3 weeks.
Much obliged, Your Lordship. 17.
It's a joint prayer, my lord. May this matter may come up after 2 weeks, my lord.
Item number 2, Your Lordship.
Item number 2.
2014 matter.
Yes, my lord.
Is this that subsidy matter?
Yes, my lord.
You're not keen to pursue the matter?
Lordship, actually, Mr. Paul is out of station, Your Lordship.
On prayer made by the parties, this is matter after 1 week.
Lordship, I beg to mention item number 8 as well, Your Lordship.
On prayer made by the petitioner, this is matter after 2 weeks.
Lordship, similar prayer for item 11 and 14, Your Lordship.
Item number?
11 and 14.
11 and the respondent, Your Lordship. No objection, Your Lordship.
On prayer made by the petitioner, not objected to by respondent. This is matter after 3 weeks.
Obliged, Your Lordship.
You have it?
14, Your Lordship.
14.
49 for respondents.
On prayer made by the appellant, this is matter after 2 weeks.
Highly obliged, Lordship.
Your Lordship, item number 15. The conducting senior advocate is still under medication. So give 3 weeks, Your Lordship.
My lord, no objection because Mr. Senior GA is also on sanction leave, Mr. Subhashish Sen. So no objection.
Mr. L.M. Sangma, letter counsel for the appellant, has sought for time in this matter on the ground that the senior conducting counsel, Mr. S.P. Mahanta, is indisposed on health grounds. Prayer not being objected to by the respondent, the same is allowed. This is matter after 3 weeks.
Highly obliged, Your Lordship.
My lord, I beg to mention item number 18, my lord. Needs 1 week time to...
18 already mentioned.
No, I missed, my lord, sorry.
What else you...
No, my lord, I
need
thought
to-
it is still there in the
I
list.
thought you want to concede, then we can...
No, my lord. I thought it is still there in the list and I'll be waiting.
Lordship, I beg to mention item number 6, Lordship. Lordship, this is for filing of written submission, Lordship. I pray for 2 weeks' time, Lordship. Item number 6. Mr. Bora is appearing for the state respondents.
Have they filed their...
He has filed his written submission, Lordship. I'm yet to file it. 2 weeks' time, Lordship.
On prayer made by Mr. H. Harmi, learned additional senior GA, seeking time to file the written argument.
Written argument.
The same is allowed. This is matter to 2 weeks.
Obliged.
Supplementary process, item number 1.
Lord, the written argument has been filed, my lord. Judgment I'll be filing it. List of citations and the filing.
For the state respondents also I have filed, Lordship. Written argument.
You have filed?
Already filed, my lord. Only as because last time I had sought time for my lord some citations. My
Okay,
lord.
so
That I'll file it, my lord.
have you done it?
My lord, I'll file it today only, my lord.
Madam,
I have
posted for judgment, my lord, so that it, since they're filing it today, obviously it has to be now posted for judgment.
provided, my lord, if any, if any,
All the respondents have also filed?
I have filed, Lordship. For the states also I have filed.
if any further clarifications required, my lord, this honorable.
You see, the only thing is that as far as authorities are concerned,
My lord,
the other side only needs to counter those authorities with
my lord.
relevant authorities. So if they are okay with just you filing the said authorities, then it's okay.
Let them give us a copy, my lord.
My lord,
Now,
they
if
have not
you-
given a
if-
single copy to me. They expect that I'll give them a copy.
We have not given him.
No,
But it's
on the last occasion, my lord, I had made a
see,
prayer. They said it's
written
not
argument. Written argument are always is desirable to be exchanged. So you should have done that.
We have served, I think.
You have not served.
Please give him a copy. So that would be academic, or you need to respond to that.
Apologies. But the thing is that because last occasion I had made that prayer, my lord. They said that it's not necessary.
In fact, see, as it is the respondent who should get a copy of your written argument to respond to it.
My lord.
Thereafter, when all the the written argument has been exchanged, nothing remains.
My lord, as far as the authorities, my lord, I'll be filing it today, my lord. Thereafter, if this honorable court, my lord, feels that any
See,
other
this
further...
is the problem, because if God forbid you don't file it today, what will
No, my
happen?
lord, I'll file it today. I'll file it today.
Then the counsel for the petitioner has submitted that the authorities relied upon by the petitioner may be allowed to be filed in course of the day.
My lord.
As such, list this matter on Monday for acknowledgement of the same.
Yes.
On Monday we'll acknowledge it, and then matter will be reserved judgment.
My lord.
Yes, yes.
Obliged.
Obliged.
Lordship, the written arguments were required. Mine is ready.
Your Lordship, I beg for some time, I pray for some time to file the written submission.
By today?
Tuesday, Your Lordship.
By Tuesday. It's mostly on law points only. Have you given him a copy?
Not yet. I was hoping maybe I could hold on and we file at the same time, but Lordship has already expressed Lordship's view in the previous matter, so I'll give a copy. They can respond to that.
Learned counsel for the petitioner has submitted that the written argument has been filed, to which the learned counsel for the respondent has sought for time to respond to the same. As prayed for, place this matter on Tuesday.
Much obliged.
Daily causeless, item number 1.
Lordship, I humbly pray before you that if this matter can be taken up at the end of the board, Lordship, as the learned DSGI is on next.
By the look of things, I don't think anything survives in the board. You're just to file your written argument, isn't it?
No, my lord. If Lordship recalls, there was just one point that Lordship wanted me to check up on. Under that Reorganization Act,
okay.
The meaning of the word relief. Because what I was saying is what I was trying to
28.1.3.
28.1a.
So,
yes. So what I was trying to impress upon this honourable court is that I am not covered under that.
Okay.
Because first three kinds of proceedings clearly don't apply to me. It is only the fourth. Proceedings where such proceedings seeks relief in respect of any order passed by Guwahati High Court. So I was trying to impress, or I was trying to convince this honourable court that my case, my petition is not covered under that also, because I'm not seeking any relief as such. So Lordship wanted me to check up on the meaning of the word relief.
Yes, because on the face of it, you see relief as in the merits of the case.
Yes, my lord.
And relief as in, being allowed to do something.
Yes, my lord. So, what I had submitted on the last occasion was that there are some, what I could find that time was some old English judgments. So, I'm ready with those judgments, but whenever they are.
You have you made up the list?
Lordship, it's just one judgment plus a law lexicon, my lord, a law dictionary.
Will you give them a copy of that?
Very well.
Let them respond to it.
Very well. But I would need to place it and explain the significance.
Oh, you need to place it.
Yes, yes.
So we'll have it on Monday then.
Monday, my lord. If Lordship, if Monday could kindly be avoided, my lord. Any other date, my lord.
Whatever. 1 week then.
1 week. 1 week.
On pre-made by the parties, this matter after 1 week.
Obliged. Highly obliged.
This is interesting. You see.
Yes, my lord. It is interesting.
I would like to.
Yes, my lord.
Actually delve into it and see.
I was forced to look at judgments from 1908, 1905. It was interesting for me at least. We'll come back after 1 week. Fine. Obliged.
Item number 3.
Yes, what is required here?
What are the respondents?
My lord, senior counsel was supposed to give a reply to them, my lord. But due to some personal difficulty, it appears, my lord, I need some more time, my lord, for the state to respond to the
jailbreak
termination.
Only with regard to the
the inquiry report.
Yes, inquiry report. But he has since retired.
He has retired.
The only question that remains is, well, as far as the occupation of the quarter is concerned, since he has retired, he has to leave. But the only thing is that because he is looking at the areas, isn't it?
Because it's a case of termination, so he is not getting the service benefits. So that is why they are waiting after the relief from this court in this disciplinary proceeding. In case that disciplinary proceeding is set aside, then only there is a chance for him to get the.
Have you looked into the matter and considered whether the principle or doctrine of proportionality will apply?
That aspect we have not looked into it, my lord.
Just look at it. If that will apply, you see, as far as the quantum of punishment is concerned, termination can be converted to removal or compulsory retirement, so on and so forth.
Our ground is that the inquiry report also is not passed as per the
yes,
rules,
that's true. But that, you see, it's an irregularity, not an illegality per se.
To the article of charges, there is no proper finding.
See, if there is no proper finding, if, like I said, you see, if the procedure has been wrongly adopted, whatever the case, you still have to address the basic issue that you have done something wrong, for which it's required to determine whether you are guilty or not. So for that, you see, time and again you've seen how courts function. They would go send back the matter to the authorities to deal with it and start a de novo inquiry or whatever.
Fresh
but in your case, it makes no difference.
He has already retired.
He's already retired. So you just look into that and see.
Look into it.
Whatever, it's up to you.
After 1 week, man.
Mr. Sangupta, learned additional senior G, has submitted that the learned AAG, Mr. K. Khan, who is conducting this matter on behalf of the respondent, is indisposed for the day and has accordingly sought for accommodation in this matter. On not being objected to by the petitioner, same is allowed. This matter after 1 week. I've never come across a party as this JUD Semen or Judge Semen, whatever you call it, having litigation across the board in every aspect of the matter, whether with regard to deficiency in power, deficiency in finance, or whatever.
All round. Deficiency in goods.
So tell me, what is the subject matter?
Your Lordship, this matter was heard last week.
Oh, really?
Regarding the deficiency in service, which I have submitted and cited few judgments.
Okay.
That is totally civil in nature. And whatever they are disputing is deficiency in service, whereby they can approach consumer court. And today it's fixed for instructions. Why? Because Your Lordship was queried me regarding why I did not go and appear before the trial court.
Okay, please.
So, Your Lordship, what has happened is that a complaint was filed in 2018. Just a brief submission what has happened, Your Lordship. They had ordered some goods from us, grinding balls. Then they paid an advance amount of, in short, of 8 lakhs out of the 54 lakhs. Then they gave us post-dated checks. Then when we wrote to them to send us some more money, they said like, no, we're having some problem because there's some cyclone and all that. Okay. Then 8 lakhs at 5 lakhs, then 3 lakhs. Thereafter we wrote to them, they did not respond. Then what happened is that since they have given us post-dated check, we went and encashed those. It bounced. After it bounced, we issued legal notice. Then within the 15 days, after expiry of 15 days, we filed 138 before the Raigad court. The notice was issued. Against that, they filed a revision before Raigad district session judge. Their revision was dismissed. That happened in 2016. Suddenly now in 2018, after 2 years, as a counterblast, they file a criminal complaint under 200 against us.
Relating to the same subject matter?
Yes, relating same subject matter. Now, by reading to the pleadings also, Your Lordship, it is seen that the cause of action arose in 2016. There were several meetings we've had. They admitted that there's some deficiency in the service which we had supplied to them. But nevertheless, they never pursued. But instead, file a complaint against us just to harass. Why? Because the appellant also is not from Shillong, nor from Northeast. He is from Chhattisgarh. So just to compel him to appear before the trial in Crieriat, they file a complaint case. Now, I'll just take Your Lordship to Annexure 11.
Page
70. Kindly say.
Yes.
So I have come before this court under 482 for quashing of the entire proceedings. My main ground is that, Your Lordship, the dispute is totally civil in nature. There is an abuse of process of law, abuse of process of court. Page 70, 3010, this is the order. Seen endorsement from learned ADC Judicial. This proceedings, Your Lordship, was at the time when the executive was not separated from the judiciary. Seen endorsement of learned ADC Judicial for disposal of the complaint filed under section 200 CRPC by the complainant, registered as CR number 3 of 2018. The complainant appeared through learned counsel so-and-so. Statement of the complainant is taken and recorded accordingly before this court today. Issue bailable warrant of rupees 50,000 to the accused person with a copy of the complaint petition. Fixed 28/11. Now what happened? The next order, Your Lordship. Kindly see the next order.
Yes.
Handwritten. 28/8/2019, Your Lordship. That is
less than a year. What happened in between, only the complainant knows, whether they pursued the complaint or not. Now, the next order. Case withdrawn to my file and put up today. Seen application for certified copies. Checked and verified from records may issue. BA prepare copies. Case endorsed to Sri S. Marwan for disposal. Now the case has been endorsed to another court again. Now, next page, Your Honor. Page 71. The following page, 71, Your Lordship, Annexure 12.
Yes.
2811. Learned counsel for complainant present. Learned counsel for the complainant submit that despite the BWA being served upon the accused person, still the accused person failed to appear before this court and hence pray for non-bailable warrant of arrest to be issued against the accused person to ensure that the accused person appear in the next date. Issue NBWA against accused person Sri Deepak Mittal.
This is 28/11/2018.
2018.
The order is 2018.
18.
But you are referring to the earlier order, which is
That's a confusion. In fact, this order should come first. Now, what happened after this? This is only after a month. Now, only in the submissions made by the council, the court never recorded that after seeing the records, it appears that the BWA has not been executed. So, it deems fit for this court to issue. Now, on submissions of the council, after a month, issue a non-bailable warrant of arrest against me. Now, what happened
initially
after 10 months?
You have not been
We've
served with
never
summons.
never received. Only after when we had a meeting with them, then we came to learn that they have filed a criminal complaint against us. Then accordingly, because my client is from Chhattisgarh, he had engaged somebody in Cleariat to apply for certified copies. And what happened? We approached this court in January. We filed this on 1st of February 2020. And Your Lordship is well aware at that point of time, the corona was already started in the mainland when it came to Meghalaya in the northeast. That it came in the month of March. That is why it was difficult for my client also to come from Chhattisgarh to Cleariat. That is why it has prevented him to appear before the trial court. And secondly, Your Lordship, I would like to, because I've relied 3 judgments. First judgment I've relied, which I placed before this court, was there's no specific allegation made against any of the directors. That I've relied on one judgment, which is very recent. And regarding another 2 judgments which I've relied was they're trying to paint the color of a criminal complaint when the entire dispute is of civil nature. Now, what I have here. And I'd like to place another judgment of 2007, volume 12. Because why I'm relying on this judgment, Your Lordship, paragraph 46. Paragraph 46, page 16.
You've given them a copy?
Copy.
Yes.
The court must ensure that criminal prosecution is not used as an instrument of harassment for seeking private vendetta, or with an ulterior motive to pressurize the accused. On analysis of the aforementioned cases, we are of the opinion that it is neither possible nor desirable to lay down an inflexible rule that will govern the exercise of inherent jurisdiction. Inherent jurisdiction of the High Court under 482, though wide, has to be exercised sparingly, carefully, and with caution, only when it is justified by the test of specifically laid down in the statute itself and in the aforementioned cases. In view of the settled position, the impugned order cannot be sustained. Now, Your Honor, paragraph 51. The same page, paragraph 51.
Yes.
The issue of non-bailable warrant involves interference with personal liberty. Arrest and imprisonment means deprivation of the most precious right of an individual. Therefore, the court have to be extremely careful before issuing non-bailable warrants. In my case, it was fixed 1 month before the next date itself. On submissions made by the complainant, NBWA has been issued.
No, Mr. Nombri. So thereafter, after the NBWA was issued, you have not entered.
We did not receive anything. It was never executed, in fact. If it was executed, we would have received the complaint and the BWA against us.
But later on, you must have come to know
We
it
had
because
a meeting. We had a meeting with them. Then we came to learn, Your Lordship, about it. So that is why, Your Lordship,
So since the inception of the complaint, you have never appeared before the trial court.
No, no.
And what is the order of the court then? After NBWA could not be executed, a process, is there, either under 82, 83, whatever. Has that been followed, or whether you have,
We were
committed
not
yourself to-
aware. It only in 2020 we came to learn about it. We immediately applied for certified copies. Then we came before this court. Imagine, Your Lordship, a complaint has been filed also after 2 years. I will have a judgment on delay, Your Lord. Paragraph 16 and 17.
That's 368. Yes.
2023, Your Lordship. But yet reported. Paragraph 16. No, 13. Sorry. Paragraph 12. Paragraph 12. That apart from bare perusal of the complaint filed before the court and on the basis of which FIR was registered at so-and-so police station on 20th February 2009, it is discernible that except bold allegations made in the complaint with regard to theft of bus in question, there was no material or document produced by the complainant to substantiate the allegation against the appellant. Even after the investigation of the said complaint, there was no evidence collected by the investigating officer to manifestly satisfy the ingredients constituting the alleged offences under 468, 471, 406, 120B of IPC. Even if the allegations made in the complaint as well as in the charge sheet are taken in the face value, none of the ingredients constituting the alleged offence are called out. The learned senior counsel, so-and-so for the appellant, such strenuously urged relying on the documents pertaining to the transfer of ownership and registration of the said bus, that the said documents were executed by the then authorized person of the so-and-so Kolkata. In our opinion, the said documents could not be considered in these proceedings, the same being not part of the charge sheet papers. In any case, there is nothing to suggest from other documents on record, so it appeals that the investigating officer had even bothered to collect any cogent or substantive evidence against the appellants to prosecute them for the alleged offences. There was no expert opinion obtained or scientific evidence collected on document allegedly forged to show as to whom, when and how the theft of vehicle had forgery committed. Under the circumstances, allowing such prosecution to continue will only be an empty formality and would be gross wastage of the court's precious time. It cannot be gainsaid that the High Court have power to quash the proceedings in exercise of powers under Section 482 of CRPC, to prevent abuse of process of any court or otherwise to secure injustice. Though the powers under Section 482 should be sparingly exercised with great caution, the said power ought to be exercised if a clear abuse of process of law is made out by the accused. Instead of Karnataka versus Muniswamy and others had held that the criminal proceedings could be quashed by the High Court under 482 if the court is of the opinion that allowing the proceedings to continue would be an abuse of process of court for the ends of justice, require that proceedings to be quashed. Now, Bhajanlal, Your Lordship is well aware. Now, paragraph 15. In state of AP versus Golconda Lingaswamy and another, this court had observed that court would be justified to quash the proceedings if it finds the initiation of or continuance of such proceedings would amount to abuse of process of court. As regards inordinate delay in filing the complaint, it has been recently observed by this court in Hasmuklal Divora versus another versus State of Tamil Nadu that though inordinate delay in itself may not be a ground for quashing the complaint, however, the unexplained inordinate delay must be taken into consideration as a very crucial factor and ground for quashing a criminal complaint. In the light of the aforesaid legal position, if the facts of the case are appreciated, there remains no shadow of doubt that the complaint filed by the respondent complainant after an inordinate unexplained delay of 8 years was nothing but sheer misuse and abuse of process of law to settle the personal scores with the appellant, and that continuation of such malicious prosecution would also be rather abuse and misuse of process of law, more particularly when neither the allegations made in the complaint nor in the charge sheet disclose any prima facie case against the appellant. The allegations made against the appellants are so absurd and improbable that no prudent person can ever reach a conclusion that there is sufficient ground for proceeding against the appellant accused. 18. Before parting, a few observations made by this court with regard to the misuse and abuse of process of law by filing false and frivolous proceedings in courts need to be reproduced in the court of Dalip Singh versus State of Uttar Pradesh and others. Was observed that for many centuries Indian society cherished two basic values of life, that is Satya, truth, Ahimsa, non-violence. Mahavir, Gautam, Buddha and Mahatma Gandhi guided the people to ingrain these values in their daily life. Truth constituted an integral part of justice delivery system which was invoked in the pre-independence era, and the people used to feel proud to tell truth in courts irrespective of the consequences. However, post-independence period has seen drastic changes in our value system. The materialism was overshadowed, the old ethos and the quest for personal gain has become so intense that those involved in litigation do not hesitate to take shelter of falsehood, misrepresentation and suppression of fact in court proceedings. In Subrata Roy Sahara versus Union of India and others, it was observed as under. The Indian judicial system is grossly inflicted with frivolous litigation. Ways and means need to be evolved to deter litigants from compulsive obsession towards senseless and ill-considered claims. This is a decision relying on delay, Your Lordship. There is no explanation in the complaint why there was a delay of more than 2 years. That itself constitutes an abuse of process of court. And secondly, Your Lordship, if an alternative remedy is there under 245 of CRPC, but Your Lordship, why we're here? Because that remedy provides for discharge. Now, why we're here? Not only for on a complaint there we can go there and get ourselves discharged, but in instant case there's a clear abuse of law, Your Lordship. It's the criminal complaint has been made to look like it is a criminal offence. That, Your Lordship, have relied on 2 judgments, even from the pleadings. It is clearly a case of deficiency of service, where only a competent civil court can take up. That is why I'm before Your Lordship. I'm praying, Your Lordship, that entire proceedings should be quashed, and the manner in which the complaint has been taken up before the executive magistrate at that point of time need to be looked into. Much obliged.
Yes.
Please, Your Lordship. Lordship, so far as the proceeding before Raigad, it is completely different. It has nothing to do with this complaint that we filed. And Lordship, to apprise the court, while we filed this complaint in 2018, Lordship, as you can see from Annex 10, Your Lordship,
next year,
then Your Lordship.
Page
Page 63, Your Lordship. Lordship, just bear with me
This
for
is the
a
complaint.
minute, Your Lordship. Lordship, may come to para 7, Your Lordship. That is on page 65, Your Lordship.
Yes.
The day after, on 12/02/2017, a joint inspection was carried out at the cement plant of the complainant at Wajar Narpo village, East Jaintia Hills, Meghalaya, between the representative of both the accused person and the complainant, and the minutes of a meeting in connection of the aforesaid joint inspection and meeting was thereupon prepared, and over and above the said meeting and inspection, the representative of the accused person had concurred that they will decide regarding with the media balls. Lordship, because actually in the year 2016 and 2017, we were in communication with them, and they have made a concur that we will do something to compensate or replace the inferior media ball. But to that extent, they didn't do anything, Lordship, which compel us to file a complaint before the Learned Trial Court at Clariat, Your Lordship. And Lordship, as I have submitted earlier, Your Lordship, proceeding there is at a very premature stage, Your Lordship. And after this, what they have submitting that they didn't know and they came to know after, they can file for recall of that order in the Learned Trial Court also, Your Lordship. They can also file for the dispensation before the Learned Trial Court also, Your Lordship. They can place the grievance before the Learned Trial Court, Your Lordship. They, Lordship, in this 2000 and this Endar Mohan Goswami and other would my learned senior have placed before Your Lordship in this 2007-12 SC.
Yes.
That paragraph 46, Your Lordship.
Paragraph
46, Your Lordship.
46, yes.
Lordship, this paragraph is also very much helping us, Your Lordship. If you come to come to the 6th line, Your Lordship. Inherent jurisdiction of High Court on Section 482 CRPC, though wide, has to be exercised sparingly, carefully, and with caution, and only when it is justified by the test specifically laid down in the statute itself and in the aforesaid mentioned cases. Lordship, as Your Lordship is very much aware, Section 482 of the Code is used in a very sparing manner, Your Lordship, in the areas of the rare case, Lordship. So, Lordship, I pray for Your Lordship that this matter can be sent back to the Learned Trial Court, Your Lordship. And Lordship, earlier also, Lordship, they also have a remedy under Section 244 of CRPC, Your Lordship.
200?
244 and 245, Your Lordship. Lordship, if I may read Section 244, Your Lordship.
You just mind. Please.
When in any warrant case instituted otherwise than on a police report, the accused appear or is brought before a magistrate, the magistrate shall proceed to hear the prosecution and take all such evidence as may be produced in support of the prosecution. As subsection 2, the magistrate may, on the application of the prosecution, issue a summons to any of its witnesses, directing him to attend or to produce any documents or other things. And then came to Section 245, Your Lordship. When accused shall be discharged. if upon taking all the evidence referred in section 244, the magistrate considered for reasons to be recorded that no case against the accused has been made out, which, if unrebuted, would warrant his conviction, the magistrate shall discharge him. Nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case, if, for reasons to be recorded by such magistrate, he considers the charge to be groundless.
Yes.
Which is why, Your Lordship, they can go before the learned trial court, Your Lordship, and place the grievance before the learned magistrate, Your Lordship. And then thereafter, magistrate exercise accordingly, and then which will not burden this court under section 482 of the court, Your Lordship.
Yes.
This is why, Your Lordship, this application need to be rejected, Your Lordship.
Any authority?
Lordship, may grant me some time on that. I'll place authority.
You should have come prepared. See, if you come, fully prepared with your case, if you are to substantiate any point by relevant authority, if you have no authority, then it's up to you. Yes, Mr. Hungry.
Your Lordship, the case here is that if it is a case of discharge simpliciter, it would have gone before the trial court. But can you see, Your Lordship, if it is, in my humble submission, prima facie, it is a civil dispute. There's a clear abuse of process of court and harassment.
Lordship, the
complaint,
if the complaint
from the plains. That is why, just to make me come to clear it on every date. Although 205 is there which provides for dispensation, but
yes,
look at the manner in which the proceedings, 18, only 2 dates were fixed, thereafter it was fixed on 2019 in the month of October, which goes to show that it's an harassment. Why? Because they're not even pursuing the matter in a bona fide manner before the trial court. It's only that we've come before this court, then only they've come, raising all these objections. Even though taking on face value that they say cause of action 2017, complaint was filed in 18 after more than a year. Now if a criminal offence is made out, if somebody enters my kitchen or my house today, I'll file a complaint after 1.5 years. Your Lordship, that is, if you say that if the allegation is very serious in nature.
Lordship, if they are aware, they should have made even one appearance before the trial court, Your Lordship.
He has explained that.
I've explained.
The fact that
138, they fail in 138.
The fact that even the court having issued the non-bailable warrant of arrest has not pursued the matter.
How can they? Because they have even not even appeared before the Learned trial court, even through the lawyer also, Your Lordship. Directly after 1 year, they came directly before Your Lordship.
Yes, that will be looked into. Anything else?
Lordship, I'll place some authority, Your Lordship.
What authority? So you do it by Monday, eh?
Lordship, 2 weeks, Your Lordship.
Why 2?
No, Lordship.
2 weeks.
Yes.
See, nowadays it's a fast-paced world. In fact, you just need 5 minutes for that. You just Google it and get it. What is there?
Tuesday, Your Lordship.
Wednesday. Third Learner Council to the parties. The respondent, upon conclusion of his argument to the Learner Council, has submitted that may be allowed to produce relevant authority in support of his submission. As prayed for. It is List this matter on 24.
24th.
That's Wednesday. Good enough for you?
24th, those matters will be there. Trust matter.
It's just to...
Once that started. 23rd, not. To avoid any kind of Tuesday.
So you can do it by Tuesday?
Yeah, 4 days time.
That's some homework for you. This is matter on Tuesday.
Obliged.
Obliged.
May I please, Your Lordship? Lordship, I've been instructed by the counsel, Mr. P. Yobin, counsel for the petitioner, that so far we cannot establish a contact with the accused, humble accused person in this matter, Your Lordship. Therefore, we have written through email that we'll be retiring from his case. So far no reply has been received yet, Your Lordship. Therefore, I was instructed, Your Lordship, either may pass an order for, because Lordship, we cannot establish any contact with the accused person, since Your Lordship was very kind enough to grant time for the settlement in this matter, amicably settling between the parties. But since Lordship, we cannot contact him, or neither he has contacted, and we tried our best to contact him, but so far no result has come out, Lordship. Therefore, Your Lordship, we cannot pursue anymore with this case, so we have ultimately written a true email that we will be retiring with this case.
But have you got a reply to the email?
Not yet reply. Your Lordship, if Your Lordship permit, I may be allowed to bring on records the
submission is good enough. What we'll do is, to be fair to the parties,
yes,
we'll give you, this court will grant you some more time.
Yes, sure.
Try to establish contact with the petitioner.
Yes, Lordship.
And then you get your instructions.
Yes, Lordship.
Make your submission.
Yes, Lordship.
Learned counsel for the petitioner has fairly submitted that efforts have been made to contact the petitioner, even through email, but till date no confirmation has come, to which the learned counsel that has submitted that one more opportunity may be allowed for this matter to for specific instructions to be received by the council on pyramid. Seems allowed. List this matter after 2 weeks.
Debut by Lordship.